Hi, this is Cora Stack here, Dr. Cora Stack. I just wanted to share with you a revised version. I've been thinking about a couple of more ideas that I needed to integrate into this paper that I'm very proud of, because I think it's asking major questions about our legal systems and what it's doing to our societies. And I've been thinking about other points that I could add to this. So this is, I hope, my final version, and you shouldn't really put up your first version on Academia Edu because it's quite hard to take it down. So this is my final version. It's called Justice Denied is Freedom Denied: The Power of Negotiation and Towards an Arbitration First Society for Peace in Ireland and Worldwide. So it's by Dr. Cora M. Stack, PhD, moi, 2025 winner of the Ramanujan Memorial Award for Excellence in Academic Leadership. Introduction. Justice denied is freedom denied. This is not just a slogan, it is the lived reality of millions of ordinary people in Ireland and across the world. Justice is supposed to safeguard dignity, equality and accountability. Yet when justice is inaccessible, unaffordable and captured by elites, freedom itself becomes an illusion. This paper argues for systemic shifts towards less adversarial dispute resolution, where negotiation, mediation and arbitration form the first stage in resolving most disputes, whether in employment, family, consumer or civil, before courts are reached. Such an arbitration first model, grounded in the power of negotiation. I got this from Harvard, but they're copywriting it now. They were sending me piles of stuff, and they must have said, that one's reading it all. She's taking it free. I read it all, it was brilliant. Now you get less, you see, they've copied on to me. Can reduce conflict, increase fairness and strengthen local cohesion. The peace process in Northern Ireland, like others worldwide, demonstrate the transformative capacity of negotiation. Agreements that once seemed impossible were made possible not by adversarial victories, but through structured dialogue, trust building and principled compromise. This same power must now be harnessed in everyday justice systems. The human cost of denial. Without access to affordable justice, citizens face silence and isolation. Families fracture, small businesses collapse, and grievances fester unresolved. I'll just give you a couple of references that I've got. As Dame Hazel Genn, one of the world's leading socio-legal scholars, has shown in Paths to Justice 1999, when people lack accessible mechanisms for dispute resolution, they often abandon valid claims altogether. The result is not just financial loss, but profound social exclusion. This echoes Lessons of the Good Friday Agreement, 1998. I had my paper in the Irish Times, where years of denial, denied recognition and blocked channels of negotiation led to cycles of violence. It was only when dialogue was placed at the centre that peace began to take root. The systemic problem, this is really a big thing now for me. I'm fascinated by it. Legal capture. Did you ever feel like you were captured by the legal profession? Say no more. Legal systems. So I'm captured by legal capture. Well, just captured intellectually by legal capture. The systemic problem, legal capture. Legal systems worldwide have been captured by insiders, lawyers, judges, and legislators trained in the same profession. Katharina Pister's The Code of Capital 2019, mentioned my previous video, which I'm now improving, demonstrated how law has been repurposed to entrench wealth and privilege rather than protect citizens. Maroe Capitelli and Barrett Grant's classic Access to Justice project, 1978. Now, these are research papers and books that anybody who's interested in this concept of legal capture might like to delve into. Remains the benchmark showing how procedural barriers deny fairness to ordinary people. And let's look at Richard Abba. Now, his work is seminal in this area as well. Richard Abel, there was a great, Richard Abel, The Politics of Informed Justice, 1962, English Lawyers Between Market and State, 2003, exposes how professions protect their own monopoly while limiting reform. I mean, we'd often call that kind of closing the ranks, maybe. As Deborah Rode, Access to Justice, 2004, argued, too often the system is designed by lawyers for lawyers, not for the public it is meant to serve. The power of negotiation, from conflict to cohesion. Negotiation is not weakness. I've shown this in the past few days. I've negotiated a few on-long deeds for fantastic people in the county councils, top brass in a number of Irish county councils for, candidates, and I have to say the people involved are top brass. Others weren't able to do it because, the county council chambers didn't have, the technology. And I have to say, the people that negotiated were, top brass we don't realise what top brass people we have at all levels in the county councils, but we certainly have top brass. I have, I've had the privilege to meet these top brass people, and they're second to none and a pleasure to deal with, absolutely. And the negotiators are really top class. You spot them, they're brilliant. They're absolutely brilliant. So it's a transformative power. So negotiation is not weak. You see that these people now in Irish public service, there's top brass actually there, because I met them in the last while. Negotiation is not weakness. It is transformative power that shifts disputes from a win-lose mindset to one where mutual dignity is preserved. Carrie Meadow, a pioneer in negotiation studies, also has shown how problem-solving approaches can reframe conflicts into opportunities. Dispute Processing and Conflict Resolution, 2003, for anyone who's interested in it. The Northern Ireland Peace Process, the South African Truth and Reconciliation Commission, and peace initiatives in Colombia all show that structured negotiation is capable of breaking seemingly endless cycles of hostility. So if entire nations can move from violence to dialogue, then surely families, workers and communities can do so also. Arbitration first, a practical path to reform. If courts are too costly and adversarial, alternatives must be built. There's no point in giving out about this and that if you can't offer a solution process, or at least offer a dialogue towards solutions. Arbitration first systems infused with negotiation and mediation are amongst the most promising pathway. Win-win outcomes, encourages problem solving, not combat. Lower cost, faster and cheaper than litigation. Calvin 2014. Reduced hostility, protects families and workplace relationships. I mean, if you look at all our systems, so many of them are all, black and white, and they end up in all these very costly investigations, which are often shelved, and recommendations, and they kind of, a lot of the time, favour the establishment position, and they can often offer, suggestions for improvement, but this never happens, and the cost of these investigations, ends up, which a lot of the time end up supporting the establishment. It's ridiculous. It's a waste of money for investigators and things like that, when the investigators and their talent could be much more directed into this kind of arbitration kind of system. Reduced hostility, protects families and workplace relationships. Broader access, this is very important, empowers ordinary citizens. Efficiency, frees up courts for serious constitutional and criminal issues. For family law, Lawrence Booley, Mediation Skills and Techniques, 2011, and Hilary Astor and Kristen Kinkin, Dispute Resolution in Australia, 2002, shows how mediation leads to less relitigation and better outcomes for children. Now, I'm saying we need trauma-enforced mediation. We need experts in trauma, but we'll say trauma is what I'm saying. That needs an extra layer of I would say, of qualification there, or ability, etc. For employment disputes, Alexander Kaplan's research 2014 shows arbitration is faster and far less costly than litigation. For consumer disputes, Christopher Hodges' Law and Corporate Behaviour 2015, these are just reference for anybody who wants to read them, documents how ADR-based systems resolve millions of claims that would never reach court. So there you have a resolution system which uses arbitration to solve very difficult and complex disputes that would never, result, never reach court. So winners and losers in an arbitration first society. So this is my big kind of picture, really. My big pitch is this huge move from our current legal system, and I'm advocating it, that it's needed worldwide for we'll see, and later on. I think I've thought about this for a long time, and winners and losers in an arbitration first society. Winners: citizens, families, workers, small businesses, communities. They gain affordable access to justice and the dignity of being heard. Losers: vested interest in the legal profession, who profit from delay, complexity and adversarialism. As Mark Galanter famously asked, why the haves come out ahead, 1974, repeat players thrive in litigation systems stacked, that's a very good word, against ordinary people. Negotiation first and arbitration first reforms can level the playing field. A new emancipation, I like this one as well, because I'm a County Kerry woman, just as a proud County Kerry woman, just as Daniel O'Connell fought for Catholic emancipation, we need a new emancipation for the working majority. Without justice, democracy itself is hollow. As Frank Sander proposed in the 1976 Pound Conference, courts should become multi-jewel courthouses where negotiation, arbitration and mediation are not afterthoughts but primary entry points. This vision, still unrealised in most countries, remains the gold standard of reform. The peace processes in Ireland and abroad have shown us that when adversarialism gives way to negotiation, the impossible becomes possible. This lesson must now be applied not just to nations, but the daily struggles of ordinary citizens. Conclusion: justice must belong to everyone, or it belongs to no one. The power of negotiation, as proven in peace process from Belfast to Bogota, must now be embedded in our legal system. Capicelli and Garth provide the theoretical foundation for access to justice reform. Pista shows how law entrenches inequality. Jen offers the empirical evidence of unmet legal needs. Menko Meadow builds the intellectual architecture of negotiation and ADR, while Calvin and Hodgins provide data proving its efficiency. If we embrace arbitration first, negotiation first justice, we can build a more cohesive, fairer, and I believe peaceful society. If we do not, we risk continue down the path when justice is for the few and not for the many. So these are my points, and I just want to conclude by saying that my understanding is either the current Chief Justice of Ireland, this is now his hearsay, so I stand to be corrected, is actually, in favour of arbitration. So, I mean, so I heard this on the grapevine, and I think it's quite interesting that our views are converging by complete accident. Now, I can't say for definite that this is his view, but I heard it on the grapevine that our Irish Chief Justice, perhaps, or the previous Chief Justice, is in favour of arbitration. So this is the sort of model I'm presenting. Maybe he'd have a different presentation, but I don't think it will be too popular perhaps at the moment, but perhaps with me and him it might make a difference that we're both on the same page with regard to the urgent need to move from our current legal system to, let's make it again, to the power of negotiation and towards an arbitration first society for peace in Ireland and worldwide. And thank you, and thanks to the people that watched my previous video, which was below par for my own standards. But I was working on it, it was an edit, and I was working on it, and this is the final edit. So thank you very much for listening, and I hope this will raise awareness and consciousness about the dire need we have if we want a peaceful world to change our legal systems.